Good morning, students. I hope you're all having a nice time, especially with the news by ICAI that the exams will be conducted with a slight delay, that is somewhere from 21st of November. So since we have more time, I expect that you students after the classes get over can revise well and then appear for these examinations in the most positive manner. Do not take this as against you. This is for your benefit, maybe from health perspective, education perspective, preparation perspective. Now with this positive note, let's go to the chapter that we're going to study today. For your CA final exams, you have the subject, you have the law in fact, if I may say, on Arbitration and Conciliation Act. And that's what we're going to take today. Arbitration and Conciliation Act. Now, I'll quickly do a screen share so that you can see across the notes, which would act also as a ready referencer for you for the examination purposes. I hope the screen share is available with all of you now. Now, see, if I have to really first talk about Arbitration and Conciliation Act, what exactly is it meaning? Like, obviously, when we have a dispute coming up, for dispute resolution, we always generally have in the end of an agreement saying that this particular dispute, if so arises, will be falling within the jurisdiction of the courts of Delhi, the courts of Karnataka, the courts of Bombay, so on and so forth. But then what is the purpose that Arbitration and Conciliation Act then serve? There are many times when you feel that it is not that only taking a dispute to court would be the best mode out. Courts also at that time say, they direct parties in fact, that these parties should first move to alternate dispute resolution methods, which include arbitration, which include conciliation, which include judicial settlement, which include mediation. This had been held in a landmark decision on Salem Advocate Bar Association, Tamil Nadu versus Union of India. So, this was one landmark judgment where the courts directly stated, okay, do not get this matter to court. We're not going to decide. What you're going to do is you go to alternate dispute resolution method and get us the finding and the conclusion out of that particular method for the purpose of the dispute that you're raising here before the court. This is what arbitration and conciliation do. They give you alternate dispute resolution methods. Now what happens? If I have to quickly give you a snapshot. Say if I pick up an example of a few years prior. Now what happened a few years prior? At that point of time, you had a dispute between Ambani brothers. Now if I weave it up into a story and say, now Ambani brothers, they did not have a dispute which was moving to the court, but a dispute which was moving to the internal court of the family, that is the mother, subsequent to the death of late Shri Dhirubhai Ambani. Now what happened? We had Mukesh Ambani at one side, we had Anil Ambani on the other. Now when you had Mukesh and Anil Ambani on either sides, and they were disputing on how the business has to be distributed between the two, how the properties, assets, cash has to be distributed between the two brothers. At that point of time, the mother called Mr. K.V. Kamath. And they together heard both the brothers. They took the stand that both of them had in respect of it. They discussed the same with the arbitrator. Now, who's the arbitrator? The arbitrator, one was the mother, two was Mr. K.V. Kamath, who is also the consultant to the mother, that is Srimati Kokhilaben Ambani. Now, when this dispute was being referred to this particular internal court of the family, they decided to arbitrate the matter in that particular internal court. Now, this internal court of the mother and Mr. Kamath came out with the resolution to this particular dispute without getting to the legal mechanism of it. They did not opt to get to the court, and the court would have told them that, okay, here we're going to hear both the parties, first the petitioner, and then the respondent, and then whatever the court feels is in the interest and respect of the distribution of the property and the assets of late Shri Dhirubhai Ambani, they would pronounced the verdict or the judgment, as you say. Here, instead of going to the court, they decided to adopt an alternative dispute resolution method, and the final conclusion came. Now, I do not mean that every time you sit with your mother over a fight with your sibling, that's going to be an alternate dispute resolution method. But this is just for the purpose of an example to make you guys understand that this is when the court does not take the verdict. The court says, adopt a method like this and come back to me so that I can note this arbitration order in my judgment, and I say that this is what the exact law is, or this is what has been pronounced or decided in this particular matter. Now, very quickly, there's first an amendment in respect of Arbitration and Conciliation Act, and that is in respect of the scope, extent, and application. Now, earlier, there was certain restrictions in respect of Jammu and Kashmir. But subsequent to the Reorganization Act of Jammu and Kashmir, this act now extends to the whole of India, inclusive of Jammu and Kashmir. So the said act extends to the whole of India. Now, what is the importance of this legislation? Of course, we did discuss the Salem Advocate Bar Association, Tamil Nadu versus Union of India as the very first point here, where methods like these were directed to the parties to be adopted. And what are these methods? The alternate dispute resolution methods. Second, there was another matter in 2012 in respect of which, in the month of February in 2012, came out a judgment by the High Court of Madras. Now, when I say there is a judgment by the High Court, you can always use it as a reference throughout all courts in India, but majorly applicable directly to High Court in Madras because the same bench has been pronouncing the matter, such an order. So that ways, let's quickly go to this judgment since you know the applicability now. This was in the matter of A.K. Balaji versus Government of India. Now what happened was, earlier foreign lawyers were debarred to come and represent in arbitration matters in respect of a contract which was in relation to a international commercial arbitration. So what is that? Now, international commercial arbitration is, let's say for example there are two parties, one is an Indian party, one is a foreign party, maybe somewhere from outside, from Russia say. Now if there's one Indian party, one Russian party, earlier the law was, prior to 21st of February 2012, that foreign lawyers in respect of such commercial arbitrations, which are of international nature, where either of your parties are a foreign party, the foreign lawyers cannot appear in the arbitration proceedings being conducted in India in respect of even an international arbitration. But subsequent to this particular judgment, foreign lawyers could not be debarred. They could come to India, they could practice in the area of arbitration, where they could appear and represent their clients in respect of disputes which were arising out of a contract which was related to international commercial arbitration. Now, basically, if I say there are four methods of dispute resolution: arbitration, conciliation, mediation, and negotiation. Now, what's in my course? Arbitration and conciliation, mediation and negotiation. We will see a bit of it, that we understand what is the difference between these four. But the majors that we have to take is arbitration, conciliation, mediation, and negotiation. Arbitration and conciliation out of these four. Now, very quickly, before I move forward, I would like to gain an understanding as to how many of you know even a bit about this, or maybe have had an experience directly or indirectly, because since you're in CA final, then of course, and you're appearing for exams, so maybe during the course of your articleship, you may have definitely gone through this particular process of dispute resolution in certain matters. So quickly in the next 30 seconds, my dear students, tell me how many of you are aware of these particular methods of dispute resolution And so far, of the two judgments, of the small example that I have shared, if you have any doubts, please come ahead and share the doubts right now. Come on, students, my eyes are on your chat portal. That I see what are the questions that my dear students are going to share, or some understanding on these particular modes that you're going to share with me right away. Okay, so far, no doubts. Probably I'll have to presume that none of you have had an experience pertaining to this. And therefore, with that understanding, I think I'll have to be more elaborative in terms when I am talking about this particular law. Now, that is how it helps me. When I'm discussing a particular topic, I need to understand my students as well, and that is what your doubts make, make and contribute towards a difference. Now, this particular law came up on 22nd of August 1996, and therefore it is the Arbitration and Conciliation Act 1996. Further, what adds to it? Legal Services Authorities Act 1987. And third, the Code of Civil Procedure 1908. So these are the legislations that together govern the arbitration and conciliation, or arbitration and conciliation as more. Now, what was the need for having this particular framework? What was the need for having a special law or a specific law pertaining to arbitration and conciliation? See, earlier, if you say prior to this, we all know about United Nations, right? So the United Nations, in their General Assembly, they had recommended that all countries shall give due consideration to the UNCITRAL model on international commercial arbitration, UNCITRAL, say, conciliation law, and the conciliation rules. So, to bring about that particular uniformity in respect of the international legislation, the Indian legislation was put into place, and therefore in 1996, we had the Arbitration and Conciliation Act 1996 being enacted and enforced in the Indian structure. So, this is majorly for the international commercial practice that this law was brought about. Now, when I talk about what this UN law was, or what was stated in the General Assembly at that point of time, so the General Assembly had certain recommendations. The first recommendation was that where there is an international commercial arbitration as having a dispute, and the parties seek an amicable dispute settlement, that they do not wish to go in the legal manner where they say, okay, we will file a suit and we will proceed with the legal structure or a legal framework. So, if they want an amicable settlement in respect of a dispute arising, they may do so by referring the dispute to conciliation. So, this model law first was proposing, the UN law, as per the General Assembly of the UN, was proposing to you the conciliation. Then, subsequently, of course, you had A.K. Balaji versus Government of India in Madras. You had the Salem Advocate Bar Association, which again strengthened this law further in the Indian context, and thereafter people started using arbitration as a mode of settling disputes. Now, This particular law, it's divided into 4 segments. If I talk about Arbitration and Conciliation Act, it has 88 sections, 7 schedules. Now, Part 1 deals with arbitration. Part 2 deals with enforcement of provisions pertaining to foreign awards, or wherein foreign parties are concerned. Part 3 deals with conciliation, and Part 4 has certain supplementary provisions. Now, what is covered for our examination purposes? Provisions related to arbitration, provisions related to arbitration agreement, arbitral tribunal, of course, which is the authority in this, and the commencement of conciliation proceedings. Now, what are the methods under these legislations that we were talking about? The Arbitration and Conciliation Act, the Legal Services Authorities Act, and the Code of Civil Procedure. We have arbitration, we have conciliation, we have mediation, we have judicial settlement, we have lok adalat, and we have a permanent lok adalat. So these are 6 methods which are there to us. Now, even if we move further, why exactly do people prefer this? Like, for example, think of it. When the dispute pertaining to Mani brothers was being taken up by the mother, and when they were preferring not to get to the court, and when K.V. Kamath was assisting their mother, what was the cost they would have incurred on it? Negligible. Maybe is it transport cost from one place to another for Mr. Kamath, because the rest of the family was there itself, in the same house. At that point of time, they were living in the same house somewhere in Kolaba in Mumbai. The lower costs. Greater flexibility, because they could multiple times sit without fearing law with the arbitrator, that is the mother and Mr. K.V. Kamath, and discuss. There is a higher level of confidentiality. They knew that they were discussing the process to come out for a resolution. They were discussing the process to come out with a solution. And they were discussing the process where the data, the details, the facts, their side of the story, their version of the story would be restricted only with those who are concerned with that particular arbitration in either manner. That is the mother, Mr. K.V. Kamath, and the other brother. And there is a likelihood that this would generally result in a settlement which is favorable to both the parties, or in the interest of law, favorable to the person who is likely to be receiving the favorable judgment or the favorable side in the arbitration process. Then the choice of forum, the choice of solutions is as stated by the parties to arbitration. That is, they can decide if they want to go to the arbitration. They can decide what reliefs are they seeking. Now, if you go to the court, you'll always see, okay, if I am going to the National Company Law Tribunal, what kind of matters I can take there, what kind of reliefs can I seek? If I'm going to the High Court, I can go on matters of fact, matters of law. If I'm going to the Supreme Court, I will only go on the matter of law. But when I'm going to arbitration, I am taking my problem for a solution. I am taking my issue, I am taking my dispute for a settlement. So the aim here is different. You do not see that what is the kind of matter or what is the kind of solution, whether or not the arbitration can bring it about. No, if there is a dispute, you can always refer the matter to arbitration, provided one, arbitration as a solution. The particular dispute is either stated in your agreement or maybe any other method of alternative dispute resolution is stated in your agreement which has been entered into as a possible method. Or second, either of the parties agree to go that particular method. So then, it's just that there should be an agreement, either side, maybe either from the side of the parties or from the side of the agreement that is in force. And then you can discuss the possible solutions which needs to be undertaken in that particular dispute. Here you do not see whether this particular section gets applied, and then therefore whether I or not I can pray for this relief before this court. And that's only for the courts. That's not there for the alternate dispute resolution. Now, what are the disadvantages? Because right now we're talking about, okay, what were the advantages, why people go for ADRs? Now, what are the disadvantages? Now, when people go for ADR, what is required is that both the parties should cooperate. Both should assist the arbitrator with facts, figures, details, information, documents, as in what is required. If either becomes non-cooperative, this method fails. Then there should not be a power imbalance between the parties. Now, what do I mean by power imbalance? See, power imbalance could be a situation where either feels that I'm more powerful, I can influence the arbitrator, and they start behaving in set manner. That is something which is a disadvantage, and that is what fails this particular method as well. Then generally, since this is not the legal way out, in fact, when I say the legal way out, definitely it is legal since it's governed by a specific law, the Arbitration and Conciliation Act 1996. But here you're not visiting the court. So, since you're not visiting the court, therefore, interim measures are generally not happening. You cannot go and pray for an interim relief before the arbitrator. What you can do in this particular manner or method is you'll have to plead your side and you will have a final judgment only. You cannot have an interim measure, say, while I filed this matter, this particular thing has happened, so I want a quick relief first, and then you may hear the matter and final order may come from the side of the arbitrator. So that is not allowed under this particular mechanism. Difficulty in enforcement of final outcome. You're not going through a legal route. So if either of the parties disagree, they may not allow enforcement of the final judgment or the final outcome of the settlement, which is coming as a result of the alternative dispute resolution. Now, before I move forward, I will give you around a minute's time to get through with what we've just discussed. And your doubts are welcome so that I may accordingly move forward and discuss the balance areas or the balance provisions pertaining to Arbitration and Conciliation Act as applicable for your examination. Students, I'm waiting. Quickly on your chat portals. Type down your questions and share it across. I'll quickly scroll it back up so that you guys can easily go through. First being Salem Advocate Bar Association Tamil Nadu, second being AK Balaji, foreign lawyers cannot be debarred for arbitration proceedings in India, for international commercial arbitration. Then you have methods of dispute resolution. Then you have legislation. Then you have again other methods. And of course, the advantage and the disadvantages. Okay, so there's one question which is coming from Calcutta. Please explain requirement of corporate behavior. It is not corporate behavior. I would like to correct you, Nishant Kajaria from Calcutta. Nishant, this is about cooperative behavior. See, when you resorting to an alternative dispute resolution method, idea what you'll have to think is that if certain information is desired by the arbitrator, you will have to cooperate. You will have to provide the data, facts, information, any documentation which is imperative to be put forward in this method. You will have to be providing that particular data, information, documentation, or anything of that sort to the arbitrator, to the other party, as stated, as desired, as directed by the arbitrator. So it is cooperative behavior that is cooperating in the process than corporate behavior. I hope you understood this, Nisha. Any further doubts or queries by anybody else is also welcome. And since I already had one query, I would wait for another 30 seconds for you students to share subsequent doubts if they are there. Or at 7:30, 1 precisely, we would move ahead to our next topic. Very quickly, Nishant, I want you to confirm back if that's clear to you. And any subsequent doubts in the interim to also follow. All right. So no further doubts coming. I would move to the next topic, which is there for our understanding. Now, just like every other section, here section 2 also talks about definitions. But before we go to the first major definition, as per law in section 2, let's quickly dissect the word arbitration to understand the same. Now, what exactly is arbitration? We'll first say it is a method of dispute resolution because it's a method of alternative dispute resolution. Now, if I take again the example of the Amani brothers, they had a neutral third person. So both the brothers are equal for the mother. The mother was a neutral body. A neutral, one or more neutral third person are selected by the disputing parties. They hear the matter. They observe everything, they receive the documentation, and they then give a decision which is binding on both the parties. So, a method of dispute resolution involving one or more neutral third person selected by the disputing parties, they're selected by the brothers, that mother you want to hear us, and whose decision is binding in nature. So this arbitration has a few defining features, or if you say this is divided into 3 characteristics: method of adjudication, neutral third person, rendering a final and binding decision. Now, another term that we had right now during the course of the discussion come across was international commercial arbitration. Now, what exactly is an international commercial arbitration? Now, if you remember, or let me quickly pose a question to you. Since we just discussed international commercial arbitration, in some other context, in this particular discussion, now what exactly was this context? Where did we just discuss about international commercial arbitration? That was not the definition being talked about, but that was something else right at the starting of this particular chapter's discussion. So where exactly did we discuss international commercial arbitration? I want to see how attentive were you. Quickly remind me, students, Where did we just discuss about? In what context did we just discuss about? International commercial arbitration. Uh, Nishant, it's always preferable, you're CA final students, so it's always preferable that you go ahead and remember case laws. I do not say that it is mandatory, but it's always preferable and definitely gives you an edge in examination and states that you understand what law is. Because when we talk about practical perspective, see, when I appear in NCLT, what happens is uh, I have to quote case laws to make my case strong, to strengthen my matter. That is what a professional adds differently. Today is not the time when we professionals are only here for certification attestation services or audit services. You're here for consulting, role representation services as well. And for that time, every judgment makes a difference. So if you know the judgment, definitely from practical perspective and examination perspective, it becomes a defining feature or gives you an extra edge as against the others. So I say it is preferable you name the exact case law, but at the same time, I also say that you should quote the correct name or don't quote the name at all. Say, for example, if I know, I cannot remember the name, but I know this is a Supreme Court judgment in this particular context, then maybe you can state that as per a judicial pronouncement laid down by the apex court or laid down by the Supreme Court in relation to international commercial arbitration, it was held that. So that kind of a line would be saving your skin. And if you're not in the habit of learning the case laws, this will not cut down marks because you would then provide the correct judgment with this kind of an opening sentence. And that is permissible. But if you write a case law, that's better. But do not quote a wrong one. I hope that's clear, Nishant. I'm moving forward for you students, and I am quickly waiting. Where did we last discuss international commercial arbitration right now? Come on, come on. My eyes are on your chat portal. See if my students remember when and where just we discussed the national commercial arbitration right now. All right, so I have one who is saying that there was judgment that we discussed from the High Court of Madras, and the answer is absolutely correct. So, multiple answers coming, but then you students do remember. So, let me take it as done at this point of time. And as I take it done, I would move to the definition of international commercial arbitration. Now, since we're coming to arbitration and we're talking about international arbitration, they generally do not, until and unless stated in the agreement or in the contract, they do not take it. So, there should be first a legal relationship which should be arising out of a particular contract or could not be arising out of a contract as well, maybe it is not laid down still in documentation. This activity or legal relationship should be considered commercial, that is, either side should be gaining money or money's worth out of the concerned contract, oral or written, and at least one of the parties should be a national or should be a resident in any country other than India. So one of my parties is an Indian party, the other party should not be an Indian party if an individual. If it's a body corporate, it should be incorporated at any country outside India. If it's an association or body of individuals, then the management and control should be in any country other than India. or it will be the government of a foreign country. So, one of my parties should be an Indian, but say if my Mr. X is from India, then Mr. Y should be maybe from US, UK, Russia, Australia, any other country outside India. If X Limited is from India, Y Limited would be from any of these countries, so on and so forth. Or say if XYZ as an association or body of individuals has its management and control in India, maybe PQR should have its management and control in a country other than India. Or the other party should be a government of a foreign country. So if that is the case, then the matter is a matter of international commercial arbitration. Now, since I used the word party, so here the word party shall be the parties in an arbitration agreement if it is laid down in a written format. Similarly, if you just like up in the starting of this particular chapter, we were talking about the word arbitral award also when I told you what are the contents of this particular chapter. Then the arbitral award, my students, deals with, if I talk about what the law states here, it includes an interim award, that is an interim relief, generally otherwise not happening if I talk about it, but they otherwise do not state any other meaning for it. What is an award? Simply to understand the decision or the outcome of the settlement of the arbitration process. Third, arbitral tribunal. The arbitral tribunal is the members or the arbitrators who are hearing the matter. Together they are known as the arbitral tribunal. So if it was Kokilaben Ambani listening to the dispute of the brothers, she was the arbitrator, she was the arbitral tribunal for them. If it was Kokilaben Ambani and KV Kamas together who were hearing, they formed the arbitral tribunal in that particular. And before I move to the process of arbitration, I have a few responses or maybe a few questions. Okay, so one was Nishan thanking for the answer on case laws, whether or not to remember. You're welcome, Nishan. Second was Gigi Jose. He stated AK Balaji versus Government of India. So there were a few of you who stated that, okay, this was pertaining to High Court of Madras, but he stated AK Balaji versus Government of India, where foreign lawyers can come to India and appear and represent in matters pertaining to international commercial arbitration. Absolutely correct, Gigi Jose. Now, let's quickly come to the process of arbitration. May come as a question. I'm not saying that it will, but of course it's a process. Could be in any 2 marker, 4 marker, 6 marker, 8 marker, so on and so forth, depending on how the examination committee drafts this particular question paper. And I'm independent, I'm not dealing with it. So do not take my word as if it's a part of the question forum, but could be. So we've just discussed that this arbitral tribunal, this neutral third party, who would hear the matter, who would adjudicate upon the matter, that is hear, go through the documents that are submitted, and give an arbitral award, which is a binding decision on both the parties. So this neutral third party shall be selected by the parties. I will not say both parties because there could be multiple parties to the arbitration process. So first party could select the arbitrator, second party could select another arbitrator. Jointly, these two arbitrators could select another third one also. So that could be possible. There could be possible that both these parties have agreed to another arbitrator, a common one. That is also permissible. There is also one situation where if there is a written agreement where they have decided that, okay, we will resort to arbitration as a resolution process to a dispute, if it so occurs, then at that point of time, the arbitrator could also be named in the agreement itself. And if the parties so move forward for the arbitration process, then that particular arbitrator would hear upon the particular matter, so on and so forth, as stated in the agreement, if it is already spelled down to that extent. Now I quickly come to the basic features of arbitration. Now the first thing that is important as a feature of arbitration is the arbitration agreement. Now, when I talk about an arbitration agreement, it's important to note that when you're talking about an arbitration, it cannot happen without the consent of the parties. So first of all, my parties need to give their consent. Now, if the consent is already given in the original agreement when it was finalized, then that is already a consent which has been sought, that in case a pending dispute arises, it will be in respect of such dispute, the parties will move to arbitration, and the seat of arbitration shall be in Delhi. So the arbitration agreement is already finalized to that extent that, okay, in case of dispute, arbitration, the consent has been given by the concerned parties in the agreement itself when it was being signed. Second, this agreement shall specify clearly that the intention and the desire of the parties is to arbitrate, and therefore, before going to the court at any point of time, they will have to first approach an arbitrator, get the matter heard. Say if the agreement states that, okay, the parties shall move to arbitration, seat in Delhi. That is, my arbitrator shall be stated in Delhi. And if I approach the court for that dispute, the court will ask for my agreement will state arbitration, and the court will say you have not followed the process that you have stated. So the first that you have to do in such a case of a dispute where you've already stated arbitration as a method of resolving the disputes, you first have to go to the arbitrator. Now, since your agreement is a binding contract, therefore, this mandation of going to the arbitration and as per the seat of arbitration fixed in your agreement. Now, if I come to the definition of the term arbitration agreement, let's quickly break that down into certain words or maybe phrases as well. And this is an agreement by the parties. Obviously, my parties are consenting in the written agreement, so it is an agreement by the parties to submit to arbitration all or certain disputes that may arise or which may have arisen between the parties having a defined legal relationship. They have a legal relationship which is defined. They know who are the parties to this particular agreement or contract, and they have themselves submitted themselves that in case if there is a dispute or there so arises a dispute, then they will move to arbitration. Then the reference in a contract, if there's a reference to a contract, in a contract, in relation to a document which contains an arbitration clause, or about constitution of an arbitration agreement or tribunal, then the same shall be enforced first. The next word that we talk about shall be arbitrator. But before that, again, since we're talking about a completely alien topic to you, because obviously the Companies Act, SEBI, FCRA, this was something that probably during the course of your articleships, you guys have heard that more. Let me again give you a 30 seconds breather where you could maybe think more about this term, and in case if any doubts arise, share the same in the chat portal so that your doubts are solved before we move to our next term, that is arbitrator. Okay, Sri Lekha has already in the interim. Ma'am, could you please explain what is arbitral award? Sri Lekha, if you could see this particular diagram on the screen, We will be talking about arbitral award here in detail as compared to what we've just discussed. So you could please wait for another 10 minutes or so and we would come to the term arbitral awards in detail. Any other doubts, students? You're welcome, Shileka. I think with that I can comfortably move because there was one doubt which is clarified and no further doubts have come. No further interactions you guys feel is required for arbitration agreement. And therefore, I move to my next topic, which deals with the term arbitrator. Now, what exactly does the term arbitrator mean? Now, if I come back to my initial example, which was dealing with the Amani brothers and Mrs. Kokila Ben Amani, then my arbitrator was the person who was hearing that particular dispute, who is going to give the final decision or the final outcome in respect of the dispute which has arisen. So, somewhere or the other, since the person is giving the decision or the outcome, so my arbitrator is similar to the judge of a court who is going to hear either sides and give the decision or the outcome in respect of the said dispute. So my arbitral tribunal or my arbitral tribunal shall be same, is similar to the judge of a court. Now, obviously, because why? Because he or she, my arbitral tribunal, my arbitrator, will be hearing to the disputes and deciding the disputes which have arisen between the parties who have come to arbitration. Now, just like my judge is an impartial person, judge of a court is neutral. The judge of a court is, say, not favoring any specific party otherwise and has to command a specific role. So will my arbitrator or my arbitral tribunal shall do. They will be neutral, they will be impartial, they will hear the matter and not favor any particular party unduly. Now, you cannot choose your judges. You can always choose your arbitrators. So when I choose my arbitrator for my matter, I have more confidence instilled in that arbitrator, and that is why I go ahead and choose that particular arbitrator. So it imposes my confidence in the arbitrator. It increases my confidence in the process. It gives me more faith that the decision taken by the arbitrators, since they're neutral, they're partial, and appointed by me as well, they will hear the matter in the best manner possible. And the decision making which will come out of the outcome or as an outcome shall be most favorable in respect of the facts and circumstances of the case of the dispute. Now, if at all subsequently I as a party feel or the court feels that the arbitrators who have been so appointed in a particular matter, they are not impartial, they are not independent in nature, they are unduly favoring a specific party, then they can be removed by the court. So my arbitrator, though he has more faith instilled, though he's said to be impartial, he's said to be neutral, he's said to be not unduly favoring a party, but in case if at a point of time it is so believed by either of the parties or by the court in any process that arbitrator or my arbitral tribunal is not independent, then they can be removed. Next, I come to seat of arbitration. Now, what exactly is seat of arbitration? If I talk about how my generally point pertaining to arbitration is drafted, that point of time, you may find that there may be a line which may be written in that particular document which may state that the seat of arbitration shall be at New Delhi. That is, my arbitrators shall hear the matter in Delhi. Or if it is written the seat of arbitration shall be in India, my arbitrators shall sit in India and hear the matter in case of any dispute which arises. So, when it says Delhi, when it says India, it also states that if there are any mandatory legal requirements to be followed in case of a dispute, if a legal system has to be followed in case of a dispute, then the one that shall be followed will be belonging to India as a country, and the matter shall be heard in the state of Delhi. And that's when I say my seat of arbitration shall be in Delhi. Then, if India is the seat, now since I was talking about Delhi, so now I will talk about if India is the seat, then Indian laws would apply to this particular dispute. If India is the seat, then the Indian courts shall have the authority to provide all supportive assistance in respect of the dispute which has been put up to arbitration or to the arbitral tribunal or to the arbitrators, as I may state. Now, in case if the arbitral tribunal would have given an award, that is a judgment or an order or a decision, and my party is not satisfied, then as per the seat of arbitration, which is decided in the agreement or the contract, if there's one, then to challenge that particular arbitral tribunal's award or judgment or decision or outcome, I will again challenge as per the jurisdiction of the seat of arbitration. So, if my seat of arbitration was stated in Calcutta or West Bengal, to challenge it, I will move to the High Court of the jurisdiction of Calcutta. Maybe to the district court if that is the case. You'll have to again identify, will this matter go to what level? It would be a matter pertaining to fact or law. You have facts or you have the law provision, then you can go to the High Court. But if it's on, and subsequently you may challenge it, if it's on facts, maximum you could go up to the High Court, maybe by a single bench to a division bench. But if it's on law perspective, you can even move to the Supreme Court. So that is how the seat would decide, the seat of arbitration would decide that what all you can do in respect, that is, your arbitrators would sit there, your legal framework should be followed as per that particular place or jurisdiction, then your challenge to the particular decision or outcome of arbitration shall also be in respect to the said jurisdiction. That is about 1. Arbitration agreement, 2. Arbitrator, and 3. Seat of arbitration. Now, I'll quickly give you a minute's time to post your doubts on the chat portal, and subsequent to clearance of those doubts, we'll move forward. The time starts now. Post your doubts pertaining to arbitration agreement, arbitrator, and seat of arbitration. My eyes are on your chat portal, students, to see your doubts, to see your queries, to see your questions. Now, had it been any other subject, probably, the reference of moving back and forth to a chat portal would not have made much a difference. But when you're talking about a subject which deals with law, and when I talk about law, I state every law is equally important. It gets imperative that I'm any of the faculties, including me, or any others as well. So we move back and forth to the chat portal. Why? Because while you're understanding the law or its framework, doubts need to be cleared then and there. Because that is what also lays your foundation for the subsequent sections that follow. And therefore, at this juncture, quickly, let's see if there are any more doubts before we move to our next topic. So in case if you have any doubts pertaining to arbitration agreement, arbitrator and seat of arbitration that we just completed, share it right now. Okay, so far no subsequent doubts, and therefore I move to my next point of discussion of confidentiality. Or maybe first, since confidentiality needs to be maintained not just in respect of the process but also the finality or outcome. So, party autonomy and procedure will take the first. Now, I talk about party autonomy and procedure. See, the first autonomy, the first right which vests with my parties is to choose the arbitrator, choose a neutral person who's going to hear the matter. So, this is one. Second autonomy that vests with the arbitration agreement or the parties to that particular agreement pertains to what is the jurisdiction, what is the seat of arbitration. So, if they want to put it in case of international commercial arbitration, they want to say that the seat of arbitration shall be in Delhi, a seat of arbitration shall be in India, the seat shall be so. If the agreement states that the seat of arbitration should be, say, Russia, the matter would be heard in Russia. If they say the seat of arbitration would be in United States, say specifically California, then the matter would be heard in California, as stated. The jurisdiction, the choice of choosing your arbitrator, that autonomy in the process is there, that flexibility is available to my parties to the agreement. So, this is definitely one of the crucial areas because why you choose your arbitrator well in advance as to who is going to hear the dispute that you're putting up, who is going to hear you, who is going to give you the final outcome, who is to maintain your confidentiality, who is to take care of the fact that the interest of the concerned parties should not be hindered as it relates to the facts and circumstances of the case. So, who would be, say, filing the written statements, who would be filing the replies, who would be coming up with the oral arguments. That autonomy in the procedure is available with the parties to arbitration. Now, my parties have filed, my parties have selected the arbitrators, they've gone through the agreement, the seat of arbitration is ready to hear the matter, oral arguments have been put, written documentation has been supplied. The finality of outcome comes up. Now, what is this outcome? This outcome is my arbitral award. So, just like you go to a court, you hear either sides as a judge, and you put your decision, outcome, or the judicial pronouncement. So, similarly, here the arbitral award comes up, and the arbitral award is no less than the final decision or the outcome, if I may say. Now, this arbitral award, this outcome which has come up, the final outcome which has come up, it can be challenged. Now, what could that be? For example, the arbitration agreement is invalid. Sometimes people say there are no witnesses, or there's only one witness, this agreement has not been registered, so on and so forth. Then parties' incapacity to enter into the agreement, independence and impartiality of an arbitrator. They were biased, they were not neutral, they were not impartial, they were not independent in nature, or maybe an unfair procedure was adopted to hear the concerned matter. So those kind of grounds, your matter could be, your outcome of arbitration could be challenged by either of the parties. Now, once this has happened, the confidentiality has to be maintained in respect of the entire process. Now, what does this mean? The facts, grounds, circumstances, decision, everything remains private in this particular process. It is only known to the parties and to the arbitrators. All of them are prohibited to share it with other parties. So I cannot go and tell Mr. X, Mr. Y, and Mr. Z that in respect of Mr. PQR's matter, this is my final outcome. Why? Because confidentiality has to be maintained to the highest. And this could not be shared to anyone who is not involved in the process, to anyone who is not a part of, not connected to this particular matter directly, or until and unless I have a direction from the court to share certain proceedings or documentation pertaining to an arbitration. Now, why is this so? See, once you ensure, as per law, that there is strict confidentiality pertaining to a particular process, the parties shall feel free to share all information during the arbitration process so that a proper, conclusive, and a sound solution would be come up to in the entire process. With that, we're through with confidentiality and also arbitral awards, because arbitral awards are the final outcome in respect of the dispute which was submitted. So we're through till arbitral awards. I'll quickly again go back to my chart portal and see your queries in respect of the topics that we've just discussed. Alright, so far since no queries, I'll quickly move to enforcement of arbitral awards so that you students get more time to type out your questions. Now, how do you enforce an arbitral award? See, it is enforcement happens. Say I have an arbitration which is taking place. I got the final order. I will inform the other party, who was also a party. He also knows it. So the other party will start taking such steps, or I will start taking such steps as stated in the arbitral award, or in the outcome, or the decision. If it's a foreign matter or a matter pertaining to international commercial arbitration, so when such an enforcement happens in respect of an international commercial arbitration, the enforcement will be such as it happens under an international treaty. So, my international treaty pertaining to that particular country, if there's a treaty which exists, so whatever mannerism, whatever mechanism, whatever method, procedure that particular country's international treaty with my country would state, I will follow the same process for execution of that foreign arbitral award. With that, we close down on these particular quick 8 topics. And before I move to the next segment, which deals with differences between litigation and arbitration. I will quickly await your doubts on this particular 8 topics so that we are through with this, we understand this, we are clear with our concepts on this before we get to how do we differentiate it with the term litigation. The finality of outcome would be somewhere in the process. That okay, I'm hearing it, I have understood the matter, and I'm ready to give down my arbitral award. An arbitral award is finally the decision making that happens and the confidentiality that is to be maintained. It can include, as stated in the definition of the term itself in Arbitration and Conciliation Act, it includes an interim award as well. And that was about a question from Nishant from Calcutta. Let me wait for another 30 seconds, students, before I move forward. Since I've recently had one question which we just elaborated or discussed upon, I will give the other students also sufficient time to share their queries on the chat portal or the question section. Alright, since no more queries have been received so far, I assume it's clear to all students, and therefore, taking that particular leverage of having received no questions subsequent, I move to my next topic, which is about distinction between litigation and arbitration. The first is very simple. Litigation happens in court. Place of arbitration is chosen by the parties. Maybe my arbitrator can say, okay, I'll sit at your place, I'll sit at my place, I can sit at third party's place, and I will listen. For litigation, I will have to go to the courtroom. Next, for litigation, once I file my case before the court will decide as to which judge's chamber will this matter be heard. So the judge is assigned by the court registry, and the litigants will have no say in respect of that who will be the judge in the respective matter, or who will judge the dispute which has arisen. But here, in respect of arbitration, the parties to the dispute shall select the arbitrator or the arbitrators. They will choose persons who have the experience, who have the expertise, who have the qualifications, who have the trade experience, which is appropriate for them to be chosen as arbitrators. So though I cannot choose my judge or the court, but I can choose my arbitrators. Third, my court is governed by the rule of law. So as the law shall state, so shall the court proceed. It will be governed by the Code of Civil Procedure, it will be governed by the court rules, it can be governed by any other rules which are applicable to the particular court or dispute. But here, there is ultimate flexibility. It is one, just like my parties decide who will be the arbitrator, similarly, my parties have the adequate flexibility to choose the procedures that would apply to their arbitration. Now, this could be they choose an arbitral institution, any particular organization which deals with arbitral matters. They can choose Okay, I will adopt the processes that are followed by them since I'm choosing their arbitrator. The parties could state in their agreement that what mechanism they would adopt in, say, the arbitration process, and therefore a greater flexibility happens in respect of this particular segment of arbitration as a dispute resolution mechanism. Then, in respect of a court decision, you can go for appeals on maybe multiple grounds, multiple levels. But in respect of arbitral awards, these can be challenged only on some specific limited grounds. Like, for example, the agreement is invalid, the state of arbitration is not correct, the facts stated are not correct, or could be that you're talking about, say, the arbitrator did not hear the matter impartially, he was not neutral in nature. So those kind of grounds you can go and challenge ahead in arbitral award. That is a very contrasting difference in respect of a court decision. There you will say, all right, this procedure was not followed. This judgment was pronounced by the Honorable Court without considering the said facts. This judgment is bad in law, or those facts were not provided, etc. So, n number of grounds could be created based on the facts. Then, if I talk about the next difference, when we're talking about judgments of court, it is difficult to enforce judgments of court of one country in another foreign country. But in contrast, if we talk about a foreign award, or if we talk about an arbitral award, if it is governed by international treaties, my country has an international treaty or a pact signed with another country, in respect of which one of the parties have been a party to any dispute, then, having been governed by international treaties, the major being Recognition and Enforcement of Foreign Arbitral Awards, 1958, the enforcement of an arbitral award in a foreign nation becomes much, much easier. With that, I come down to these 5 differences, which are 6 differences precisely, which are part of a differentiation between litigation and arbitration. So, students, before I move forward with my next topic on authorities under this particular act, I'll give you another a minute's time to post your queries on the query portal. Alright, I don't see any further queries coming on this particular topic, and therefore I take it as the word of my students and I move to my next topic. Now, my next topic deals with the framework, the legal framework, the authorities under this particular act. So when I talk about authorities under this particular act, I will have to first talk about that these authorities can be divided into three segments. One is judicial authorities. Two, I will have to talk about the courts. Three, I will have to talk about the Supreme Court, High Court, or any other designated person or institution which are forming part of the arbitration process. Now, first, when I talk about judicial authority, first of all, this particular term, judicial authority, is not defined under the Act. It is, however, defined under a case law which is SBP versus Patel Engineering. Now, this matter was heard by the apex court, that is the Supreme Court. What did they state in this matter is worth a hear. A judicial authority as such is not defined in the Act. It would certainly include the court as defined in Section 2E of the Act, and would also include other courts and special tribunals like the Consumer Forum. It's stating one that please blank. There is no specific definition of this particular judicial authority as in the Act. You can go to various tribunals and count it as such. So therefore, this is a wider concept. There is nothing which is predefined and preset as per law in respect of judicial authorities. So here you could talk about special tribunals as a judicial authority. You could talk about quasi-judicial authorities as a judicial authority. Their function here in this reference to Arbitration and Conciliation Act would talk about only referencing to arbitration matters. And if I have to also sum up this, I would state that every court would be stated as a judicial authority, but every judicial authority can not be a court. Every court shall be a judicial authority, but every judicial authority could not be a court. With that, we are wrapping down on judicial authority, and I move to courts. Now, this is defined. This is defined under Section 2(1)(e) of the Act. Now, since this is already defined in Section 2(1)(e) of the Act, let's quickly understand what exactly is this. See, there are two understandings of court. One is the pre-amendment era, and one is the post-2015 amendment. So there was an amendment in the year 2015. So one is pre-2015, one is post-2015. Now, prior to the amendment in 2015, the term was held to be district court and high courts which are exercising original jurisdiction. One is original jurisdiction, one is appellate jurisdiction. So when high court and district courts are exercising their original jurisdiction, that was your court as per prior to the 2015 amendment. Now, this was also subsequently held in one of the matters. Now, which was this particular case where it was held? This was Fountainhead Developers versus Maria Arcangela Sequeira. This was Fountainhead Developers versus Maria Arcangela Sequeira. So there they said that prior to 2015 amendment in the Arbitration and Conciliation Act, that is ANC Act, the term was held to be district court and high courts exercising original jurisdiction only and not the other courts. Now, post-amendment, the situation changed. This was prior to 2015, prior to the amendment. Post-amendment, however, I state, the situation changed. Now, it is the understanding, if I say, on this particular term is now dependent on the type of arbitration. Now, what is the type of arbitration? Say, if you have an international commercial arbitration, I have one party in India, I have another party sitting in US. So one is an Indian party, one is a foreign party. I will only consider my court as the high court. I can take this matter only to the High Court. And for all other matters which are not concerning international commercial arbitration, the matter would be proceeded forward by the district court or the High Court exercising original jurisdiction, as the case may be. If it's a foreign award, international commercial arbitration, I only go to the High Court. For any other matter, I go to district court and the High Court exercising original jurisdiction. Now, this court performs a lot of functions. May it be my High Court, may it be my district court. It is the primary judicial organ. It is the primary judicial organ in respect of a particular arbitration. It gives a supervisory function, that it takes care of what the parties are doing. It would include, say, granting interim relief measures or an interim award. It can challenge an arbitral tribunal. Then it can review an award which has been passed. It can give directions in respect of enforcement of an award. So that way, my court has various important functions. The next segment that I have to deal with is Supreme Court, High Court, or any other designated person or institution as a part of this framework. Now, my Supreme Court or High Court or any other person or institution, they are interested in the specific task. And what is the specific task? Of appointment of arbitrators upon request of a party. So if my parties do not have arbitrators listed, they do not come to a conclusion of a common arbitrator or set of arbitrators which are acceptable to both, they will move to the court and they would request that arbitrators be appointed in respect of that dispute. So my court will then appoint arbitrators upon the request of the parties. Now, in case of an international commercial arbitration, however, I will move to the Supreme Court requesting them to appoint arbitrators. And for domestic arbitration, I will move to the High Court having the jurisdiction, having original jurisdiction, so that in respect of those matters, the arbitrators could be appointed. I hope that's clear. Let me quickly move to the chat portal. Can we go for appeal in Indian courts against international arbitral awards? Gigi, that's your question. I'll repeat it again for everybody. Ma'am, can we go for appeal in Indian courts against international arbitral awards? Gigi, the first thing that I would state is, if the seat of arbitration in a matter of international commercial arbitration is based out in India, then against the arbitral award that is given by my seat of arbitration in India, I can definitely go for appeal in an Indian court as well. So if my seat is in India, I have to follow the process and procedure as per the Indian law. My appeal against the international arbitral award, which has been passed by a seat in India, can be made in India. I hope that clarifies your doubt, Gigi Jose. Now quickly, I'm still having my eyes on the chat portal for subsequent questions where I used to do. Considering there have been a lot of queries from multiple of you today. rather than restricting to questions only from a few. I'm here to take forward queries by each one. Gigi, I hope you've understood in respect to the response to your query which was raised by you currently in respect of appeal in an in-cause against International Arbitral Awards. And to the others, the forum is still there for you. You can put up your questions, you can put up your queries in the portal to share your doubts. All right, so we are at 8:29 right now. We are through with almost like what, 35 to 40% of our chapter in respect of what is applicable for the examination, of course. Now, subsequently, after the break when we meet, we would start with arbitration agreement, the different definition, general principles. In the process, we would talk about a few examples as well. And that's how we would take forward the subsequent portion of this particular unit. Now, as we step into the break time, what I would expect is in this particular 5 minutes break, which would end by around 8:35, if you have any doubts, you would post it simultaneously on the chat portal and not waste your time as of now when we're in the class timing. So quickly, I am calling off for a break right now at 8:30 for all of you, and 8:35 we recommence. Doubts on the chat portal, and subsequently back when we are here, we'll all be here with all our energy and enthusiasm and all our attention. See you in 5. from Gigi from Kerala, and Gigi asks that since we just stated that, okay, in case if there is a seat in India pertaining to international arbitral awards, we have an appeal which is possible in India. But what about a foreign seat in case of arbitration? Whether can we go for an appeal in India? Now, at that point of time, I did say that, okay, international arbitral award, if you have a foreign seat, you cannot appeal in India. But in case if you have a seat in India, you can appeal in India as per the Indian mechanism and applicable rules and laws. Now, what I'm stating now is only the practical perspective and not valid for your examination. So please, at the time of your examination, do not quote this. This is only possible when you deal with these kind of problems practically. And this is not relevant for your examination also from the perspective that your study material has nothing on this. Since it is not a direct requirement or direct inference or directly stated in the Arbitration and Conciliation Act. So right now what I state is only from perspective of the query which has been raised by one of you. Now, this question, I would state again what Gigi has asked. So for seats at foreign country, we have no remedy in India. We do have a remedy. But you will have to take a slightly longer route. What will you have to do? You will have to go to the international seat. Say if my seat of arbitration is based at Russia, I will have to go to that foreign seat once. I will have to make an application, either by personal appearance or through somebody. For some reason, why I am precluded to attend an arbitration proceeding over there. And I would request for transfer of proceedings to the Indian jurisdiction. And then the matter or the appeal, or there could be a remedy which could be made available to me in India. Second, if I talk about the UNCITRAL model law, basis which our Arbitration and Conciliation Act was put up. So that UNCITRAL model law also provides that if there are certain preclusions, then the matter could be referred to another jurisdiction if it is found or deemed fit or capable of being heard in the other jurisdiction. But let me again state, this is not applicable for your examination. This is only for the purpose of the query raised by Gigi Jose. Gigi, I hope you have got your answer to your query, but please again remember, this is not applicable for examination. I am reloading the query page, students, to see your query. Sorry, I apologize, I'm suffering from slight cold, and therefore you would be seeing me on and off like this. Quickly, students, any other queries pertaining to the topics that we've so far completed in the process? Alright, so far no further queries received, and therefore I take the liberty to move to our next topic, and this next topic, my students, deals with arbitration agreement. Now when I talk about, this is a query which I put up to you. So since I was receiving queries, now it's again time for me to post a query in front of all of you students. If I talk about arbitration, I talk about conciliation, I talk about mediation, I talk about negotiation, What kind of methods are these? Arbitration, conciliation, mediation, negotiation. What kind of methods are these? Thank you so much, Srilekha, for your concern. I'm fine. This is a general normal cold. Any queries, students, so far before we move forward and quickly responds to my query, which I have raised to you right now. And my query, I repeat again: arbitration, conciliation, mediation, and negotiation. What kind of methods are these known as? Come on, come on, come on. I'm waiting for your responses. So since I've already started receiving answers, let me quickly move ahead and also state the correct answer at the same time. The correct answer is alternate dispute resolution method. Alternative dispute resolution methods. Now, the next topic, as we're going to talk now, deals with arbitration agreement. So there are two sections here. First is section 2(1)(b), which states arbitration agreement, unless otherwise stated in a particular context, would be as an agreement referred to in section 7. So if there's a specific reference or a specific definition as per a particular context in the Arbitration Conciliation Act, then that shall be constituted as an arbitration agreement. Or else you will go back to the definition under section 7 of the Arbitration Conciliation Act to understand the meaning of an arbitration agreement. Now, what does this further state? So if I come to section 7, my section 7 here states that is an agreement between the parties. So there are two parties, they come into an agreement that, and wherein they decide that in case if there is a dispute which arises or which may arise between them in respect of a legal relationship caused, then that shall be known as an arbitration agreement. So my agreement should state that in case of a dispute, I will go to arbitration and what shall be the seat of arbitration for my matter. That's point 1. Point number 2, this could also be that instead of going for an elaborate agreement for an arbitration, I could have a small clause. I could have a maybe 2-liner clause, 3-liner clause, or whatsoever the case may be in my contract itself. So if I have a contract, maybe with Reliance Industries Limited, what I could state is in the contract itself, I can have a clause number, say clause X, stating that in case of a dispute, the matter shall be referred to arbitration and the seat of arbitration shall be in Delhi. The arbitrators shall be Mr. X, Mr. Y, Mr. Z. If that's so is the case, then I do not require an additional arbitration agreement. This arbitration clause in my contract with Reliance Industries Limited would be sufficient. Now, this arbitration agreement has to be in writing. Why? Because it's easier then to go to the court and prove the document. Next, an arbitration agreement should be signed by the parties. So both the parties should put their signatures onto this particular agreement so that their affirmation, their consent is established. Then, if there is no agreement, then a document, an exchange of letter, a telegram, any other means of communication, including electronic mail. So if there's something on email coming saying, okay, that in case of a dispute arises in respect to this matter, we will put this matter to arbitration, and this arbitration shall be held in Kerala. So that will be a record of the agreement. If the other party also consents and says that, okay, I agree with the said arbitration point. Then they may make a reference to say in case of a dispute, the provisions of the Arbitration and Conciliation Act shall be applicable. That shall be again sufficient. So we have different modes to make arbitration applicable. For example, for an example, if I have to say, I'll sum it up like this: either have an arbitration agreement, or have an arbitration clause, or have a document, or an email, or last, make reference to the arbitration law in your original agreement. Then arbitration law itself would state that you can move to the court and accordingly submit your dispute and get arbitration enforced. Now, what is the purpose of an arbitration agreement? The purpose of an arbitration agreement is that you can submit your disputes to arbitration and you do not need to get into the legal dispute system of court. And the law itself also is favorable towards arbitration, and that is also the reason, since it was, as we discussed in the history of arbitration law in India, it was subsequent to the suggestions made by the UN and the General Assembly that the unilateral model law in respect of arbitration is to be followed by the different countries or the contracting parties, so that alternative dispute resolution methods could be proposed in different countries in a uniform manner. So, basis that model law, we have this ANC Act 1996. For those who may ask, okay, what is the ANC Act? It is Arbitration and Conciliation Act. Now, what are the general principles of arbitration agreement? Now, these are some 5 general principles. These are 4 here. 5th comes towards the bottom. This arbitration agreement, first of all, it's enforceable under the law. Why? Because it's either it's coming in my agreement, or it's a separate agreement, or it's coming through law, and has the nature of a contract, valid contract. So, 1, it is an agreement enforceable under law. 2nd, consent. So, if I have an arbitration agreement and the parties have signed to it, there is a consensus of parties involved. If I have a clause in my existing agreement, that agreement is also signed by the parties. There's a consensus in respect of putting my matter to arbitration. Then, any words in the communication which indicate that there is a consent. Then, irrespective of the fact that whether or not there's an arbitration agreement, whether or not there's an arbitration clause, arbitration can be resorted to, and consent can be established from any communication between the parties. 3rd, ouster of jurisdiction. If, let me state here, point 1, if my agreement has a clause for arbitration, I'll first have to proceed to arbitration. Second, if I have an arbitration agreement in place, I will first resort to arbitration as the mechanism for resolving the dispute. Third, if during the court proceeding, either the parties has already moved for arbitration, if before the commencement of court proceedings, if either of the parties have already moved for arbitration, the other party cannot unilaterally, that is on its own from one side, proceed to the court to litigate that matter. So if one of the parties has already agreed to litigate a matter indirectly through an alternative dispute resolution method, that is arbitration, then the other party cannot move to the court. Now, there could also be one more case. If there's a dispute, one party can say, okay, we can refer the matter arbitration. Nothing's there concrete till now, but one party attempts that, okay, can we refer the matter to arbitration, and from there we can receive a conclusive solution, a constructive solution to the dispute. If the other party so requests, in respect of a dispute, so if one party so requests, the other party shall mandatorily have to first attempt an alternative dispute resolution method until and unless he feels that it would prejudice or harm his interest adversely. Next, Doctrine of Separability. What is Doctrine of Separability? See, when you talk about an independent or an arbitration agreement, let me state it that way, it is an independent agreement. It is not the main contract. Since we're talking about arbitration agreement, it's an independent one, independent of the main contract entered into between the parties. Now, say in my original contract, there was something which made that contract invalid. Maybe the main contract or the principal contract was not signed by the parties, or the language was ambiguous, or it was signed with undue influence or coercion, and it is therefore rendered invalid. But that does not mean that if my principal contract is invalid, my arbitration agreement would become invalid. So, it's important for you to understand that merely because my principal contract was invalid, it will not ensure that my agreement to arbitrate would also be rendered invalid. I can still, as a recourse, in respect of the invalidity of my principal contract, move to arbitration to find a resolution or an alternative dispute resolution mechanism. Next, competency to rule on its jurisdiction. So whatever is the jurisdiction of the tribunal, it can rule only on that. It can determine whether the main contract is valid. It can determine what are the facts. It can determine what are the documents, whether those documents are correct. It can accordingly give its arbitral award. So it is only have the capacity to rule on its own jurisdiction. Now quickly back and forth, I will move to the chat portal here so that I can see that in case if you have any queries which have been shared with me so far. Alright students, I'll give you like another minute or so. We are at 8:59. We would start precisely at 9 o'clock. Till 9 you have time to put forward your doubts here pertaining to the topics that we so far covered. Alright, nothing so far. I move to my next topic here. Requirements of a valid arbitration agreement. Requirements of a valid arbitration agreement. First, it should be in writing. An oral contract is difficult to be proven. A written contract is absolutely visible and therefore can be taken as it is. Mandatorily in writing therefore becomes the prerequisite. Now, this could not be that it's stated in one document, it could be in a subsequent document as well. There is no specific format which has been prescribed or a specific template which has been prescribed for an arbitration agreement or an arbitration clause. Say, for example, there is a company. This company has a rice mill in somewhere in Panipat, because that belt you have a lot of rice mills. And someone is willing to purchase that rice mill. So, in respect of the point of purchase of that rice mill, that may be a situation that in case of a dispute, that matter could be referred to an arbitration. One, if there is a case. If there is a case that there is a written contract between the two executors that okay, if there so and so are the conditions and these conditions are not met, then I will go for an arbitration. So this is purely dependent on the parties, that how they define, how they draft, how they create their arbitration agreement in the format that they desire. Second, clarity of consent. The intention to go for arbitration must be spelled out. The consent of either parties should be stated well in the agreement. No vague words or which do not give a constructive clarity of consent of either parties should be stated in the agreement, so that there should be an element of doubt which stays in the agreement which is there. So the agreement, the wordings, the phrases used, the drafting, that should be absolutely clear. It should disclose and determine what are the obligations of either parties, what are the duties of either parties in respect of an arbitration if the company so approaches as an alternative dispute resolution mechanism. Third, a defined legal relationship. So again, this particular word has also been borrowed from the UNCITRAL model law pertaining to arbitration or alternative dispute resolution mechanism. This statute, however, does not define this term. So my Arbitration Conciliation Act does not define this term. Here the idea is that if my law specifically states that for these particular matters, arbitration cannot be resorted to as a dispute resolution mechanism, only in those cases a legal relationship can be barred from going to an alternative dispute resolution. Otherwise, for all legal relationships, there is always a possibility, there is always an option, there is always a mechanism, an alternative dispute resolution mechanism of arbitration which can be taken forward. Final and binding award, the fourth general characteristic or requirement of a valid arbitration agreement. The award that shall be granted shall be final and binding. The third person is given the rights by the parties to decide upon their matter, to hear upon their matter, to finally give that what is the resolution of the dispute that they have brought forward between before the arbitrator or before the arbitral tribunal. So that ways, since you're already giving that particular right to the third person, who is a neutral person, who's acting as your arbitral tribunal or who's acting as your arbitrator, so my arbitrator, my arbitral tribunal shall have all the power to make that final and binding award. then there should be specific words which should be used. But though wherever I say, okay, there should be specific, there should be clarity, there should be no vague words used. But it is not required that only the use of the words arbitration or arbitrator in a clause, or the use of the words arbitration or arbitrator in an arbitration agreement will make it an arbitration agreement or will make it an arbitration clause. You can also infer from the drafting of a particular sentence, from the phrasing of a particular paragraph, that whether or not arbitration can be resorted to in a particular case, in a particular situation. Usage of exact words of arbitration or arbitrator, therefore, is not the essence. The essence, if the understanding and the drafting. Then, the next requirement, dispute. There must be a dispute. Could be a future dispute which may occur. Could be a difference in understanding, difference in connection in respect of the affairs that is being proposed to be submitted to arbitration. Next, arbitrability. Only those matters which could be proposed or submitted to arbitration must be arbitrable. That is, arbitration could be possible for such matters. Now, you cannot say that if I am, say, having a small quarrel with my sibling, I'll move to arbitration. That is not arbitrable. So, understanding the essence of the facts and circumstances, you will have to decide that whether the nature of the dispute is such that whether or not the matter could be put up for arbitration or not. Next, signature. It's only when the arbitration agreement is contained in a contract, then signature is required. Say, for example, but if your arbitration agreement, arbitration point or arbitration clause is only set, say, in terms of I have exchanged certain emails with my concerned person, with the opposite party, with the other party, if I may say it in that manner as well. And in the email, if I state that, okay, in case of dispute, I will move to arbitration, then that is sufficient. I do not need to have a contract in place for that particular task. So only if when it's in the form of a contract, I need a specific arbitration agreement. Otherwise, mere discussion in correspondence or exchange of pleadings is also sufficient to establish an arbitration agreement without a signature. And before I move to termination of an arbitration agreement, I would quickly lower down on the size of the font so that you guys can see from point number 1 to point number 8 and share your doubts or queries on the chat portal right away before we move to the next topic. All right, now I move to the next topic. And again, increase the font size, students, for your comfortability. I hope it's visible to all. Now, termination of an arbitration agreement. So, how can you put an arbitration agreement to an end? If it's a part of a contract, the contract is nullified, it's no more in force, and you do not, within sufficient reasonable time, resort to an arbitration as a recourse for any loss that could have been caused to you, then in that case, this arbitration agreement could be put to an end. Then, second would be mutual consent, that either of the parties, say there's myself and another Mr. X, so both of us have entered into a contract. This was an arbitration agreement, and therefore, after that, by mutual consent, we said, okay, we're terminating this arbitration agreement, and we do not require it anymore. Then again, you could have by mutual consent and being put to an arbitration agreement. Next, principal contract itself gets terminated either through discharge or through novation. Now, what is discharge? Whatever was required out of that contract, that particular object of the contract is fulfilled, or a new contract has been entered into. So, this particular discharge or novation shall terminate my arbitration agreement, which forms a part of the contract. But if the principal contract is breached, so I was earlier talking about discharge and novation. But in case if there is a breach of the contract, breach of the terms and conditions of the contract, then in that case, my arbitration agreement shall survive, and because of the doctrine of separability, it shall be treated as a separate contract, and accordingly, the recourse can be taken under the arbitration agreement that has been entered into by the parties to the principal contract as well as the arbitration agreement. Fourth, I'll say fourth because I put up an extra point earlier before as well. Death of parties. So if either of the parties is deceased, then in that case the arbitration agreement shall not be discharged. It shall be enforceable, just like you have a legal representative or a legal hire by succession in respect of any party. That particular legal representative or legal hire or successor can enforce arbitration agreement as well. And last, it can be extinguished by the operation of law. So if law says there's a certain law which has been put into picture and which states that an arbitration agreement shall now be discharged, shall now cease to exist, it can be extinguished, and the same shall be the mechanism. Now, quickly, before I move to arbitral tribunal, I'll give you another 30 seconds to a minute to post your queries on the chat portal, and subsequently we would move forward for our next topic on requirements of arbitral tribunal. So please quickly share your doubts, post your queries, ask questions which may have created certain doubts in your mind pertaining to this topic, and get them resolved right away. So your 30 seconds to post your doubts start now. My eyes are still on the chat portal, students. Quickly share your doubts right now. Next, students, the next that we'll not be discussing, since not received any subsequent questions, but let's just stating agreement on whatever we've discussed. So I come on to the next topic now, and the next topic right now that we'll be discussing would be nature and scope of arbitral tribunal. Now, how would this be? First, what is an arbitral tribunal is required to be known. What is the requirement? What is the duty or liability? How the members shall be appointed? What is the procedure they will follow? The manner of removal or termination of the members, termination of the authority, replacement or substitution. Now, if I talk about an arbitral tribunal, it is very synonymous to the word arbitrator, because this arbitrator is nothing but the arbitral tribunal. Could be one arbitrator, could be two arbitrators, could be another third arbitrator chosen by the first two. That means a three-bench tribunal, a three-member bench as well. So this arbitral tribunal has to follow certain requirements or prerequisites. What are these? First, this arbitrator could be of any nationality. There is no prerequisite that there should be only one nationalities of arbitrators, say for example only Indians in case of a dispute, or if say if I talk about UNCITRAL model law also, they also say that okay, you can have arbitrators from multiple nationalities. Similarly, if I talk about say an international commercial arbitration, there was also a question which had come from Gigi, where he had said that okay, do we have no remedy in India? Now, Gigi, you do not have a remedy in India here directly, as I stated. There was another route as well which I discussed, but which is not relevant for examination. But this definitely makes a difference to that query. If your parties are from different jurisdictions, if your parties are from different countries, you can have arbitrators from different nationalities to hear your matter. Say, for example, one party is an Indian, one is a Russian. You can have a Russian arbitrator and one Indian arbitrator as well, and both of them can together hear the concerned dispute. So, what could also be taken up as a resolution, this is okay. Someone may say that the Indian arbitrator would look towards the interest of the Indian party, and the Russian arbitrator would look to the interest of the Russian party. So these two arbitrators put together, appoint a third one as well, and then these three put together hear the concerned dispute, and the decision of the majority shall be final and binding. So these arbitrators therefore could be of any nationality, and they could structure the tribunal accordingly. Next, capable of contracting. Now these people should be competent to contract. This is a private arrangement. Consent of the private parties is also involved. There is a contractual relation. If the arbitrator has already been named in the agreement, his signature, his consent has already been sought before naming him as an arbitrator, there comes a contractual relation between the arbitrator and parties concerned. So, this person should be capable to enter into a contract, and only then he can be taken up as an arbitrator to a particular matter. There should be no bias involved. This person should be impartial. This person, or as the arbitrator of the arbitral tribunal, should be neutral, unbiased, impartial, independent, should not be having any sort of influence from either of the parties. And that is also one of the prerequisites. Now, when I talk about independence or impartiality, please remember impartiality is a state of mind. Independence is also a state of mind. Now, when can this happen? Say if there is no favor by one party to the arbitrator or the arbitral tribunal, then in that case, these arbitrators or arbitral tribunals have an independent nature, have an independent characteristic, have an impartial characteristic. They do not have a preconceived notion in respect of the dispute which is being heard by them. And therefore, with that kind of a preconceived notion which is happening between these parties, my students, you should understand that independence and impartiality, therefore, are an inherent part of an arbitral tribunal. Now, when you get an exam, a question in your examination, of course, CA Institute does have different segments of questions coming. So probably when they come up to you and they state, okay, what are the characteristics of this particular independence or impartiality, or characteristics of arbitral tribunal? So maybe when you're talking about these, you may also take it from the perspective where you're understanding this. You may take it from the perspective of how an auditor is supposed to be. He's an independent entity. He has to be impartial. He is not to be, say, having a preconceived notion. He has to have no sense of bias. So these three characteristics, these three requirements can be borrowed from what is expected of an auditor as well. And that's how probably it becomes easier for you to understand the mind or mindset or the capability of an arbitrator or an arbitral tribunal. Next, duties and liabilities of arbitrator. And in the meanwhile, as we talk about duties and liabilities of arbitrator, what I would want is you guys quickly go through the previous topic, share your doubts, and subsequently we would move to the next query. Now I am on the chat portal, students. So far, so good. I feel no questions received. But it's also my responsibility, but I'm sitting here as to discuss this particular topic with you for the purpose of your examination, that I take all queries which I receive from you students. So very quickly utilize that particular 30 seconds or 1 minute breather that's available to you guys and share whatever doubts you have pertaining to this chapter or this particular law, as I stated, because one particular law has been consolidated beautifully in the study material of the Institute. Now, as my eyes go left, it goes on the chat portal, which is open on a subsequent device. Now, I come to the next topic, students. Since all of you have been amazing enough with good wishes and confirmations. Now, I talk about duties and liabilities of an arbitrator. So, what is my arbitrator expected to be? Now, since I talked about earlier that, okay, my arbitrator, let's compare with an auditor. So, let's quickly make another comparison in respect of duties and liabilities of an arbitrator and duties and liabilities of an auditor. So, what is the requirement here? That the arbitral proceedings shall happen without any kind of a delay. Just like the audit has to be conducted on time. The arbitral proceedings shall be impartial, just like my auditor has to be impartial. The auditor has to maintain confidentiality in respect of the assignment. My arbitral Tribunal shall have to maintain confidentiality in respect to the matters. Then you have the requisite where you have to discuss the said matter with the concerned parties. Your management needs to have documentation. You have to obtain written representations when I talk from the perspective of an auditor. Similarly, from the perspective of an arbitral tribunal, there has to be a deliberation between the concerned parties so that you have a reasoned award. You have on whatever points you need clarifications, you can, as an arbitral tribunal, you can seek clarifications, you can seek documentation, you can discuss the same thoroughly, and then render the award which is required for the matter. Then avoid any kind of a unilateral communication. So all parties should be present before you at the time of discussion. You should not have a communication where only you meet or you discuss the matter with only one particular party. Then ensure all documents and communication received from one party is communicated to the other. So here slightly there's a difference. Here it goes as the court routine goes, that in case if one party is communicating something to the court, what is said is that it should also serve one copy to the other party. So similarly, if say I am serving a copy to the arbitral tribunal, I will also have to serve a copy of the same documents, same set of documents to the other party also, so that they know what facts I'm submitting, and in case if they want to give a contrary fact, and if they want to state that okay, this fact is not true, I have the relevant documentation, they can do that. And they can present their side, and a reasonable opportunity of being heard is available to them. Next, whatever award is being awarded in respect to the matter connected or concerned, it should be in respect of compliance with all legal requirements. Because if it is not in compliance with the legal requirements, it cannot be enforced. The entire process would be rendered futile. Then in case my arbitrator has to operate, he also will have to at all times comply with all legal requirements. Because again, if in connection with his appointment any legal requirements are not fulfilled, then his continuance, his appointment as an arbitrator can be challenged. And this could be like one measure could be, for example, since we talk about a neutral person, if one arbitrator in a matter with my client, I have an arbitration matter going on with one of my clients, and the arbitrator which I have chosen and I'm enforcing upon is my father. But the person is not neutral, the person is not biased. Why? Because he's related to me, he's not independent. And if he fails to disclose this ground that I'm his daughter, and he continues to be stayed appointed as an arbitral tribunal or as an arbitrator, then this is non-compliance. Why? Because you need somebody who's unbiased, who's independent, who's neutral, who can hear the matter impartially without a bias. And being my father, he cannot continue without being biased. These are certain duties and liabilities of arbitrator that are important for you from the perspective of examination for the purpose of knowledge as well. So I'll quickly reduce the font size so that you guys can all go through all of these and again post your queries. Quickly, I'm awaiting your doubts and queries on this particular topic on duties and liabilities of arbitrator. Since I had left the screen open in respect to the first 4 points now, I'll move to the subsequent 4 points for you to go through. Alright, now I move to my next topic. And the next topic, my students, concerns termination, removal, and substitution of arbitral tribunal. Alright, before I take up this topic, there's another question for you, and you have only 30 seconds to reply. As soon as I complete my question, you have only 30 seconds to reply. My question is, what are the maximum number of members? Minimum is 1. What are the maximum number of members that an arbitral tribunal can consist of? What are the maximum number of members that an arbitral tribunal can consist of? Repeat, maximum number of members an arbitral tribunal can consist of. Time starts now. The very basic question. Thank you, Gigi, for your message. Saying it's clear up till now in terms of doubts that I asked. All right, be quick. 30 seconds are almost over. And it's a very, very simple question. Maximum number of members in an arbitral tribunal as permitted by law. All right. So someone's just replied saying that, okay, maximum 3. Someone said maximum 5. What I would like to state, my students, here is there is no maximum number under law. The minimum, of course, is 1. Of course, since you at least have to need to have one arbitrator since you're putting for an arbitration, there is no maximum number specified under law. It is totally the discretion of the parties to the arbitration agreement or to the arbitration clause in the agreement what they decide. Next, our next topic comes termination, removal, and substitution of arbitral tribunal. Now, there could be a certain set of situations. precisely if I say 4 situations, when you would have the situation of a termination, removal, or substitution of the arbitral tribunal. First, when the arbitrator leaves voluntarily. Now, my arbitrator says, and he decides on his own volition that he would no longer be acting as the arbitrator for that particular matter. Then in that case, he will cease to be the arbitrator for the dispute. Now, this is a private consent-based arrangement. You cannot force an independent party, an individual, against his will, against his volition, to continue acting as an arbitrator. Second, when the parties involved in the arbitration agree that the arbitrator should be removed. Now, this could be any other reason. This could be a reason that they feel that he's biased. They feel that he's not able to understand the matter. They feel he's not he's not taking interest. He's not devoting his time. He cannot give a proper solution before, and where time is of essence. So those ways, if the parties involved in the arbitration agree that the arbitrator should be removed, the arbitrators can be removed. Third, operation of law. When, due to certain factual inability, the arbitrator is unable to continue. Say, for example, he's unwell. He keeps unwell. He's been diagnosed of a sickness, infirmity, or ailment. Then in that case, or maybe one of the parties has proceeded to the court citing any of the grounds, and the court feels that he should not continue, then the arbitrator shall be unable to continue as an arbitrator in the dispute. When the arbitration process ends, then again the arbitrator's term and the mandate for the arbitrator comes to an end. So the conclusion of the process itself would, by virtue of operation of law, say when final award has been made, he's not been able to make an award within 12 months of the dispute, the arbitration process and the appointment of the arbitrator shall come to a conclusion. Then, when the court decides, say, sometimes it happens that you move to the court for a legal proceeding, and during the pendency of the legal proceeding, there comes a situation that the court decides that the matter be put up to arbitration or an alternative dispute resolution method. Then, in that case, the court at a certain time may give a decision that the arbitrator should be removed or he should be changed. Then also the arbitrator has to be removed. So quickly on these points, I would again decrease the font size so that you have all points on one plate, and you can easily quickly put up your doubts to me on the chat portal. Another 30 seconds for the same. So though there is a delayed response, but Gigi from Kerala, he's just responded that parties can choose as many arbitrators. Of course, yes, that is also the answer. Though delayed, but since it's a response from you, my student, I take it on record and I state that the answer is correct. Now, very quickly, we move to the next topic. We are close to the end of this chapter. We are coming to the close of the end of this session as well very soon. And at this juncture, I would also like to remind you students, remember, this is the last segment of arbitration. Now we come to conciliation after this. What is important is you clear your doubts before the class ends. Or else, of course, yes, you have specific email IDs with the Board of Studies as well. You can post your doubts and they will reply. Now, very quickly, last segment that we're going to talk right now is about arbitral award. Now, what exactly is an arbitral award? We've had earlier questions. I think Shri Lekha had sent one question, Gigi had sent another one, and I think Nishant also had sent a question. So they were talking about exactly what is an arbitral award. So basically, whatever is the decision, the outcome of the arbitrators is your arbitral award. Now, if I talk about an arbitral award, I would like to compare it with a judgment or a decision or a judicial pronouncement pronounced by the court. So, it is similar to a judgment which has been given by the court of law. And it is like a decision on various issues in respect of which a dispute has been put forward between the arbitrators or the arbitral tribunal. So, whatever comes as the outcome of it shall be known as an arbitral award. So it has not been so specifically defined under the law as under the Arbitration and Conciliation Act. It only states that it includes an interim award. They do not otherwise define what is an arbitral award. So we will have to infer with reference to how it is in the legal system and how it is before the court in the form of a judgment and how it is here in the form of an outcome or a decision making by the arbitrators. Now, who can challenge this particular arbitral award? So, only a person who is a party to the arbitration can challenge this arbitral award. No one else, no one who is a third party can challenge the arbitral award. Third, this award can only be challenged before a court. So, if I'm a party, I will have to go to the court and challenge that this arbitral award, which is passed against me, is not in the best interest. Certain facts were overlooked, or the arbitrator was unbiased, biased, and the arbitrator did not look onto certain documents which were provided. And without going through these documents, this arbitral award has been passed on in isolation. So, on certain reasons like this, before the court, an arbitral award can be passed, an appeal to an arbitral award can be put forward before a court. Then what is the timeline? Say, this again I would say also has a play from one of the judgments, and this was Consolidated Engineering Enterprises versus Principal Secretary of Irrigation Department, and this judgment came in the year 2008. Now this was passed by the Apex Court, that's the Supreme Court. They said 30 days time period plus 30 days extension if the court is satisfied. So within 30 days from the passing of the arbitral award, the parties who's aggrieved, they can move to the court and they can appeal against the arbitral award. Subsequently, if there's a delay of further time period, then with 30 days more can be accorded. If I talk it in the legal sense, a condonation of delay of up to 30 days subsequent is allowed for the parties to file an appeal before the court here in respect of the arbitral award that was passed. Next, automatic stay. If I talk about the Arbitration and Conciliation Act, there is no automatic stay in respect of any of the enforcement of the arbitral award. You will have to specifically go to the court and request for a stay in the proceedings pertaining to arbitration. Only then there could be a stay which is possible. Now, what exactly is a stay here? You may have heard in a lot of judicial proceedings when they come up to the court. If you remember Tata Mistry time, they said maintain a status quo in respect to the composition of the board of directors at the time when there was a Tata Mistry matter pending before the Bombay bench of the NCLT, the National Company Law Tribunal, subsequently before the National Company Law Appellate Tribunal. Again, a similar status quo order was passed. Similarly, subsequent when they moved to the Supreme Court, a similar order was passed that status quo in respect of composition of board of directors has to be maintained. Now, when this was happening, this status quo was in a way telling that, okay, stay as you are. The boards of directors will stay as they are. Now, when this was put into picture, there was a stay. Nothing more could happen in respect of the change of board of directors during that time period. Similarly, if I come to an oppression mismanagement matter, 241, 242 of Companies Act 2013. Now, what happens on 241, 242? We can seek an interim relief, and that interim relief could be that the board of directors cannot dispense away or alienate any of the properties of the company. They cannot sell it, they cannot transfer it, they cannot dispose of, they cannot enforce it upon somebody else, they cannot encumber that property. Now, if that kind of an interim order is being passed, the other party, the board of directors, would come and say, no, we need to dispose of because this is the requirement. If they establish, there could be a stay on that order. Just like there could be a stay on disposal, there could be a stay on non-disposal. So similarly, here also, in the course of proceedings of arbitration, if either of the parties feel that there is a stay required on any particular aspect, they can go to the court, they can request for a stay, and that stay can be enforced in respect of the arbitration proceedings also, or in respect of a certain matter which is subject to the arbitration proceedings at that point of time. Next, types of arbitral award: final award, interim award, settlement award, additional award. Final, which is passed in the end after all issues have been submitted to adjudication or arbitration. So the last one would be the final award. Interim, during the course of proceedings, if any award is rendered, if any order is rendered, award and order is same here. So we use the word award because we're talking about arbitration. So any award is rendered and it shall continue till the end. That will be an interim award. Third, settlement award. If the parties come, sit across the table before the arbitrator, they decide to settle the matter. Then whatever comes out would be the settlement award. And last, there is a final order which has been passed, a final award which has been passed, but certain claims which are yet to be adjudicated are still pending. Therefore, for those claims, therefore, for those points, therefore, for those issues which are not yet resolved or adjudicated upon, an additional award and an additional order could be passed by the arbitral tribunal within 30 days from the date of the receipt of the final award. So I had 10 issues. When I received the arbitral award, I feel only 7 have been answered or 7 have been resolved. 3 are pending. I will again make a reference within the next 30 days to the arbitral tribunal stating that these 3 issues are not yet resolved, and then I seek an additional award in respect of the 3 issues. So an additional award therefore comes into picture. Now, what are the requirements of an arbitral award? 1, it should be decision of the majority of the members. 2, it should be in writing, it should be signed, it should be dated, because if you need to appeal, then you can within 30 days plus 30 days go in for an appeal at the court. So it should be dated and signed. It must be reasoned. You should have specific reasons in respect of every outcome or finding or decision in respect of the arbitral award. It should be clear, specific. It must not be vague. Then it should be capable of being performed, and it should not be illegal. Say, for example, I cannot have some transaction saying that, or an outcome stating, okay, since in the proceedings I have come to know that there are some drugs and narcotics, and they are on the Drugs and Narcotics NDPS Act. So this proceeding has to be carried forward as it is, and they can continue the transaction. No, I cannot pass that award because that is illegal. That is against public policy. That is against the law. So I will have to state it accordingly. Then it should be capable of being performed. So something that is illegal cannot be performed as well. So that again has to be taken care of. Then, what are the challenges to a valid arbitral award? The first, challenge of bias against the appellate tribunal. They're overstepping that. They're entering into somebody else's domain. Specific grounds that are required for reviewing an award. So, could be like incapacity by a party. Then could be an invalid arbitration agreement, unsigned arbitration agreement, where the consensus is not specified. Then other party is not informed well in advance that an arbitrator has been appointed or an arbitration proceeding has been initiated. So no proper notice has been given to the other party in respect of the initiation of the arbitration proceeding. That is also another set of grounds where you say that there has to be a challenge to the award. Then the issues cannot be submitted to arbitration. For such issues also, if an arbitration has been initiated, that can be challenged. The arbitral tribunal or the procedure followed by the arbitral tribunal was not in accordance with the necessary requirements under law. Then again, it can be challenged. Then subject matter of the dispute is not subject to arbitration. It is under a specific law and has to be taken a recourse accordingly. Then the award is in contravention with the public policy. So on these specific 7 grounds, an arbitral award could be challenged. Now, what could happen when it's challenged? 1, they could confirm that, okay, as it is, the order shall apply, or the award shall apply. 2, set aside that, okay, we do not concur with the award which has been given or passed. Therefore, we do not, we give an adverse order. 3rd, modify. They may make certain changes in the order. Now, with that, we end up on arbitration. I'll give you another 1 minute to post your doubts. Subsequent to that, we'll talk about conciliation, and it's a very specific topic. So within the next 1 minute, close down arbitration, share your doubts so that we start with our last segment of this chapter for your examination. Okay, now I come to my last topic for today. No questions so far on this. So I assume all of you have understood. The last segment here deals with conciliation. We've so far discussed about arbitration. Okay, there are disputing parties. There is one arbitrator or set of arbitrators which are chosen by the parties, whom they feel is unbiased, whom they feel are capable to hear the matter. They should be neutral, impartial, or independent in nature. This would be a confidential discussion. So here also similar to that, we have a conciliation process. Now when we talk about conciliation process and arbitration process, arbitration could be adversarial in nature. Conciliation, on the other hand, is non-adversarial. Arbitration could be enforced from the court side. Conciliation is totally voluntary. Arbitration, assistance is not required. You can appear and you can handle stuff on your own. The process on your own can be taken forward. In terms of conciliation, it's an assisted procedure. Both the processes, arbitration as well as conciliation, are confidential, and the settlement arrived at or the award arrived at is final and binding. So there's a finality of settlement. Now, what are the number of conciliators? Depends upon the parties again, but with a maximum of 3. So here, though in arbitration there is no maximum specified, here maximum can be 3, from 1 to 3. Appointment by the parties, or the parties can refer to an institution who can appoint conciliators. What can be the procedure? So once these conciliators are appointed, the parties submit their documents in writing, their statements in writing. They provide the evidence. The conciliator then say, if X provides me certain documents and Y provides me certain documents, I will give X's documents copies to Y also and Y's documents copies to X also, so that they can go through each other's documents and accordingly make further submissions. Then, before going through any other mechanism, I will give them an option to initiate a dialogue, to engage in discussions based on the information which I further receive as a conciliator in the process of the discussions between the two parties. I help them to arrive at a settlement. Now, just like there was that once arbitration proceeding is started, you cannot go to the court and approach a court regarding the same dispute, which is part of the arbitration proceedings. Similar is the case with conciliation. So when the conciliation proceedings are ongoing, the parties cannot initiate arbitration proceedings, or they cannot approach a court on the same issue, which is pending arbitration proceeding. So one is, if you started here, you should first end here and then go for an appeal only. Or else don't go for an arbitration if it is not a part of your agreement or clause. Next, difference between mediation and conciliation. Now, this is only to this particular extent only for your examination purposes. So we would not make a wider coverage. We will only limit ourselves right now to what is essential for your examination. Now, mediation, you have a mediator. Conciliation, you have a conciliator. My conciliator is a facilitator who would engage and initiate a dialogue or a discussion between the parties. He can also suggest solutions. My parties can suggest solutions. My mediator has a facilitative role only. He only attempts to guide the parties. The solution should come from the parties. The mediator, solution only from the parties. Conciliator, solution from the parties and solution from the conciliator. Then mediator, outcome is an agreement between the parties. Conciliator, there is a settlement agreement. Mediation, agreement reached by the parties is a contract which is enforceable by law because it is an agreement between the parties. They are the parties to it. Now, settlement agreement is coming from a conciliator, so it has the same status as of an arbitral award, and therefore it can be executed through the civil court. Mediation, section 89 of the CPC, Code of Civil Procedure 1908. Conciliation, part 3 of the Arbitration Conciliation Act. Both are governed by confidentiality. Confidentiality in mediation on the basis of trust. Confidentiality in conciliation defined by law. Now here, if mediation agreement is breached, the process shall follow as per breach of contract. The settlement agreement has to be enforced. So you will have to go to the civil court to enforce the settlement agreement or the award, the arbitral award, just like an arbitral award. You will go with the settlement agreement here, which is as a result of the conciliation process. Now, if I talk about the settlement agreement, which comes as a result of this conciliation process, there are a few pointers that we need to know. Very few in nature. One, the aim of conciliation, if we have to take it like that, it is to arrive at a settlement. It is to come out of the dispute with solutions being suggested by other parties as well as the conciliator. So there are suggestions coming from either sides. So initial steps is the attempt to come and conciliate, the attempt to come out with common solutions. Now, if the common solution is arrived at, then you come and enter into an agreement which is known as a settlement agreement or as a memorandum of conciliation. The settlement agreement is known as memorandum of conciliation. So, if I have, say, come to the case of Ambani brothers again. So both of them gave solutions to the mother. Okay, I'll take this company. Okay, I want this company. I want it like this. I want it like this. The mother was also hearing. She was the conciliator. She also made some suggestions. So in the end, what came was a settlement agreement. Could be referred as a memorandum of conciliation. If I take it as a context of conciliation, then the conciliator, that is the mother, will be required to authenticate the agreement. She will have to sign that particular agreement as conciliator. If the signature is not there, it will have no legal sanctity. That was also held in one of the Supreme Court matters, which was held which was pronounced in the year 2003, Mysore Cements matter. So signature on the conciliation agreement, memorandum of conciliation, by the conciliator is required. Then enforcement. So just like an arbitral award can be enforced, it is final and binding on the parties. Challenging the same before the court is separate. Similarly, a conciliation agreement, a settlement agreement, a memorandum of conciliation would also be challenged before the civil court. This one. Second aspect that we have to discuss here, or in fact the last in this particular chapter, is confidentiality. Now, just like in process of arbitration, confidentiality has to be maintained unless and until it's specified under law or there is a requirement by one of the courts to state the details for implementation. Until and unless that is the situation, it is the disclosure of any factors not required to be made apart from the parties and the conciliator. Then, if this set of parties move ahead from conciliation to arbitration, then this conciliator cannot act as an arbitrator on the same matter of dispute which was put forward for conciliation. And last, none of the views expressed, any suggestions which have been made by both the parties, any solutions offered by both the parties, any admissions made by the parties, or proposals, or any evidence put forward by them, irrespective of whether or not the proceedings relate to that particular dispute, can be relied upon in any judicial proceeding. So arbitration proceeding is separate, conciliation proceeding is separate, but this does not become an evidence when you're coming to a judicial proceeding. Even a conciliation proceeding documentation cannot become evidence in case of an arbitral proceeding. With that, we come to the end of this particular chapter. I stop the share, and in case there are any queries, my students, I'm here to take forward your queries. Quickly, I'll get through with the chat portal. The screen was not stuck, Srilekha, because I was. Had there been any issue, then I would have been informed, because simultaneously the institute does not have just a platform for you all, but the institute also has technical people who are there constantly throughout the class to monitor that there are no technical glitches or issues happening. So I wonder that may be a bandwidth issue with you, and in case next time if the same persists, then probably what you can do is you can refresh your screen and log in again for the class. Any other queries? I think with that, probably, since no more queries have come to me in the last 1 minute also, so I would take leave from all of you. And as I always say, study well, prepare well. Now you have some extra time. That's an additional line that I say today. Now you have some extra time. So revise, write your answers, practice writing answers, make the requisite amendments and corrections, and then step inside your examination hall. Do well. Thank you.